And permission. Matter, land acquisition matter for admission tomorrow. The agency is
land acquisition matter, that of discussion.
Without acquisition, they are widening the road.
Yar
The PWD.
PWD.
Acquisition ಎಲ್ಲ award ಹೋಯ್ತು. ಸುಮ್ಮನೆ ಮಾರ್ಕ್ ಮಾಡ್ಬಿಟ್ಟು ಹೋಗಿದ್ದಾರೆ.
ನಾಳೆ
The respondent, the petitioner is considered.
Huh?
It's true, serial number 2. I'm for the respondent. Petitioner is considered. But I don't have instructions. What is you're trying to settle, then I don't have. But exactly 2 weeks time. I'll either retire or
retire. I am not going to permit any retirement. Either the party should be here, or you should.
I'll make them. I'll tell them to make out.
Yes, yes.
They after a wakal.
List number 2, serial number 2. At the request of learned counsel for the respondent, we placed this matter on 23rd of August. List number 3 is regarding appointment of that auditors.
First
List number 1. So all these matters can be disposed of. I will indicate who are the auditors. I will indicate and
one auditor is appointed for around 15 cases.
Note we will do that. Yes. Disposed of. ನಾನು ಅಲ್ಲಿ ಇಂಡಿಕೇಟ್ ಮಾಡ್ಕೊಡ್ತೀನಿ ಫಾರ್ಮ್ಯಾಟ್ ಇದೆ ಅದನ್ನ ನೋಡ್ಕೊಂಡು ಮಾಡ್ಬೋದು.
Separate order is going to be made for each application.
Yes, each application. All right. Follow disposed.
List number 3. Number 3. Number 1.
Number? You know. It's number 3.
Number 2. Matter pending respondent of after vacation or before vacation, our respondent company exception matter pending is appeal also. Implement direction.
You are appealing to the respondent. Appellant. Pass over. I think they'll come. Pass over. ಅಲ್ಲಿ ನೋಡಿ ಎಲ್ಲ ಇದ್ರೆ ಅವ್ರಿಗೆ ಹೇಳಿ ಒಳ್ಳೆ ಅವ್ರ ಕೊಲೀಗ್ಸ್ಗೆ. ಎಸ್ you are for the
I'm writing a memo. The NCLT has already passed an order dissolving this company. The operative portion is at page 8.
but this is regarding Benata Spawn
Please.
Iron Private Limited.
That is. Inaka's fund.
But in the operative portion,
Please, my lord.
correct.
6-1.
Learned counsel for the respondent has filed a memo dated 9/8/2023 along with copy of an order passed by the National Company Law Tribunal, Bengaluru bench on IA number 568 of 2019 in company petition bracket IB close number 166/BB/2018. First off, learned counsel submits that the NCLT has already passed an order dissolving the respondent company. Therefore, it is submitted that the prayer made in the petition has become infectious. A copy of the same is served on the learned counsel for petitioner. Next para. In view of the order passed by the NCLT, as see from the order dated What is this? 26th of November 2019. Passed by the NCLT. The prayer made in the petition seeking to wind up the respondent company has become infectious. So the petitioner is permitted to take steps for redressal of its grievance in accordance with law. Full stop. Next para. Consequently, the company petition stands dismissed for the reasons stated above.
Orders. Yes, Mahadevan. I appear for the official liquidator. With serial number 4, Swami, Kelgade subserial number 1 regarding CA number 113 of 2023. Kindly, your lordship has the CA. CA, Swami, CA 46 another is a CA for prosecution under criminal provisions. If I may invite your attention to section 454, Companies Act, Old Companies Act, 1956. 454. (454), my lord, is a provision which penalizes non-filing of statement of affairs in time. After the passing of winding up order of the company, the first thing which the OL has to take course of is the books and account and statement of affairs of the company as it existed prior to the winding up. Because OL as a new agency only steps into the administration of the company after the winding up order is passed. Adar munche yen nadita ididdu annadu one statement of affairs anta barutte. A statement of affairs is required to be filed by the directors with the OL within 21 days of the winding up order being passed. This being a very crucial document, that sikkilla andre namge we don't have a starting point to start off to see where the affairs of the company are at. So non-filing of that is made a criminal offense under section 454 subsection 5. If I may be permitted to read.
Yes.
If any person without reasonable excuse makes default in complying with any of the requirement of this section, he shall be punishable with imprisonment.
454
subsection 5. My lord has the 1956 Act, man.
Yeah, haledu kodri.
Old Act.
Hale act kodri.
All the provisions of the old Companies Act will apply for the purposes of winding up. After the enactment of new Act and the IBC code, the matters which used to be filed here have now been filed in NCA.
Correct.
So the remaining matters will all be governed by this Act.
So for all practical purposes, this will be of no use for us.
For this court, no use. Subsection 5. If any person without reasonable excuse makes a default in complying with any of the requirements of this section, he shall be punishable with imprisonment for a term which may extend to 2 years or with fine which may extend to 1,000 rupees for every day during which default continues or both. This is a penal provision. Subsection 5A gives jurisdiction to this court to try that offense. Now, because this is a criminal process, we go back to CRPC in terms of enabling the accused taking coercive steps to get their presence before this court. In this matter, my lord, we have tried summons, we have tried bailable warrant, we have tried non-bailable warrant. The reason they seem to have not been executed is that the accused are now in United States. So the application which is filed within CA 46, which is CA 113 of 2023, is an application seeking their extradition for the purposes of trial in India. Now, this application, my lord, the prayer is not fully of extradition. Extradition treaty ideally, Swami. What happens is they only talk about investigating agency and superintendent of police who can make a request to Ministry of External Affairs to start the extradition process. In this application, because there is no police agency involved in this matter, I am asking that whatever the police are supposed to give to the MEA, Ministry of External Affairs, to start the extradition process, yav affidavit kodbeku, yav document kodbeku, instead of the police, let me as OL liaise with the Ministry of External Affairs to start the extradition process. Is the prayer that I sought. On the previous occasion, notice was issued to learned ASG. It has been served, the memo has been placed. And we are not asking any specific prayer against them. It is just that our treaty, ideally, there is no authority for an agency like OL to start the proceedings or to communicate with Ministry of External Affairs.
Why the agent Torsilla?
If I may invite your attention to order dated 21/6 and memo dated. 21/6 ಅಲ್ಲಿ ಅವ್ರ order ಆಗಿದೆ. If I may invite your attention to my memo dated 17 July, we have hand served a copy of the application. ಅಲ್ಲ, as such they will not have any objections because ನಾನು ಬರೀ ಕೇಳ್ತಾ ಇರೋದು.
But he should see here anyway. I thought his name was not shown, it is shown.
Please, service ಮಾಡಿ report ಮಾಡಿ. We have it next Wednesday, my lord. I'll personally inform one more time.
All because we can pass over if he is there, you can someone can go and get him.
Please, ma'am.
Pass over. What is your name?
Srishal Navalgund.
Srishal Navalgund.
Please.
Yes.
CA 317 of 2021, my lord. OL is the applicant. It is a money claim, original suit tara against creditors of the company. ಯಾರು ಕಂಪನಿ ದುಡ್ಡು ಕೊಡ್ಬೇಕಿತ್ತು ಅವ್ರ ವಿರುದ್ಧ ಅವ್ರು ಕೊಡದೇ ಇರೋರಿಗೆ ನಾವು OS ತರ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಮಾಡಿದೀವಿ. Under 446 subsection 2, those OSs can be instituted before this court after winding up order is passed. Under that provision, we have instituted this suit. The claim is in the range of about 2,66,000 rupees. The respondents have been served. They filed objections as well. Then the matter was referred to learned judge at CPC, registrar CPC for recording of evidence. We have recorded our evidence. It appears that their evidence is taken as not filed. On the CA hakidare Swami regarding CA 136 of 2023, it appears to be, we have not been served. It appears to be a recall application. Our hakirodu. Our examination nil anta tagonde. So serial number 5, my lord, regarding anta just below
136.
136. Otherwise, I have completed my evidence in this matter. It has to be heard. If it is heard without their evidence, I can argue today.
Yes, I have it. I have it.
Not been served. It appears to be a
Recall.
In any event, if your lordship allows it, a date with cost may be fixed so that they can do it on the same day and I can finish it.
Order on IA number 136 of 2023.
CA number.
In CA number. Huh?
ಅಲ್ಲ, ಅದು INU CA ಅಂತಾನೆ ನಂಬರ್ ಆಗಿರುತ್ತೆ. So please.
CA number 136. In CA number 317 of 2021. This application is filed at the hands of the respondent, Messrs. Manav Ispat Private Limited, seeking to recall the order dated 24/2/2023. They not furnish a copy of that order.
But it will be in the order sheet of this court only. Recorded by learned registrar.
In another 24/2 na.
ಅದು ಆ ಕಾಪಿನೂ ಅವ್ರು ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. ಐ ಆಮ್ ಅನೇಬಲ್ ಟು ಅಸಿಸ್ಟ್. 136 ಕಾಪಿ ಕೂಡ ಇಲ್ಲ.
The 24/2/2023.
I have examined PW1 on 31/1/2023. And on 15/3, respondent prays for time for evidence. Respondent evidence again on 4/7/2023. I don't know which order he is seeking to recall.
I think is wrongly mentioned. I think it was 1/3/2023. PW1 alva.
ಹೌದು ಸ್ವಾಮಿ.
Hence cross examination of PW1 taken as a nil.
ಅದನ್ನೇ recall ಮಾಡ್ತಾ ಇರೋದು.
1/3 it was.
Please.
Not 24/2. 24/2/2023. Stop. During the course of these proceedings, this court had directed the registrar.
Please, registrar CPC.
CPC.
Central Processing, my lord, they have a designation.
Center. Is it judicial or CPC?
CPC, man. Registrar CPC. Central Projects Coordinator of the registrar category.
Registrar bracket CPC. To record the evidence of the parties. Stop. The contention of the petitioner applicant that on 24/2/2023 it was recorded that cross-examination of PW1 at the hands of the respondent is taken as nil. So, however, on verifying the order sheet, it appears that the said order was passed on 1/3/2023 and not 24/2/2023 as stated in the application. So, nevertheless, this court is of the considered opinion that one more opportunity may be given to the respondents to cross-examine PW1 on payment of costs, full stop. Accordingly, the application is allowed while recalling the order dated 1/3/2023 and permitting the respondent applicant hearing to cross-examine PW1 subject to payment of costs of ₹2,000 to Advocates Welfare Fund, within 1 week from today, full stop. Acknowledgement for payment of the cost shall be filed in the office. Ordered according.
If I may make a request, my lord, only one date may be fixed and it may be noted that no further adjournments may be granted.
The next para. PW1 shall be kept present for cross-examination on 18th of August.
Please.
Usually ಎಷ್ಟೊತ್ತಿಗೆ ಮಾಡ್ತಾರೆ ಅದು?
During the day ಮಾಡ್ತಾರೆ. ಬೆಳಗ್ಗೆನೂ ಮಾಡ್ತಾರೆ, ಸ್ವಲ್ಪ ಸಾಯಂಕಾಲನೂ ಮಾಡ್ತಾರೆ.
No, because we can mention the time. That is it.
Time is not required, my lord. They issue a separate cause list.
Okay.
Separate cause list will be issued.
18th of August. So, the respondent or applicant here shall cross-examine PW1 on the set date without seeking adjournment.
It's great.
Take 1 week time for hearing on the case. 1 week time. You got on the 17th.
Which IA?
IA number
245, 251. Who has filed this application?
I have filed.
For what?
No, my colleague has to argue.
My lord, if I may just assist your lordship, it's actually a simple matter. I do not have any objections per se. CA 410 of 2022 was filed by the Airports Authority of India, seeking to undertake sale of some ground handling equipments in all airports across the country. There are about 25 airports, and that was allowed on the 9th of January 2023, giving them a time frame of 3 months to complete the entire exercise in association with the ON. They have to undertake the sale, keep me informed, and transfer the sale proceeds to someone. And the sale has to be undertaken at their own cost. This was the order passed on the 9th of January of this year. This exercise they had to complete within a period of 3 months, your lordship. Unfortunately, they couldn't. They had some difficulty, so they filed another application, CA 245 of 2023.
Extension of explanation of delay
Yes.
and for extension.
That extension, they had sought only until the end of last month. Now, of course, this application 245 is infructuous, so they filed another one, 251, seeking extension until September, the end of September. I have no objections, my lord, provided they give me fortnightly updates on what they are exactly doing to ensure the sale in terms of the order of this honorable court.
That kind of an order was not passed earlier.
It was passed, my lords, but with
The same condition you want.
My lord, same condition.
Where that order?
Now, it's passed in CA 410 of 22. It's dated 9th January 2023.
It's not available here.
It should be in the file of CA 410. I'll just pass one a copy.
Not to conduct.
You are asking to add one more condition.
Okay, my lords, the only condition is that they give us fortnightly updates. Because so far, we have received sale proceeds of 6 airports. And in all, there are about 25. Remaining 19 airports, what is the status on ground? We do not know. We do not know if they've identified buyers. They're taking steps to identify buyers. Head Kaila. At once all every 15 days on report for trade, anything we can do to assist them, we will also ensure assistance is provided.
You are appearing for whom? Then we'll allow it. That is 251.
Okay, my lords.
In fact, in 245, they had not sought for extension of time.
They had until the end of July, my lords. That application as on date wouldn't survive because they fixed the time.
July.
It's 31st July is what they asked for.
No. There is no such prayer.
And that prayer was deleted. Condone a single prayer is in that. So extension of time for that another application.
Therefore,
In that
practically there is no application for seeking extension of time in application number 245. Because you could not make both the prayers in one application.
with the seeking extension of time.
Or on C number 245 and 251 of 2023. We'll stop. These two applications are filed at the hands of the Airports Authority of India. It is the respondent in CA number 410 of 2022. Huh?
But the applicants, even in that application, even in CA 410, they are the applicants.
Which is also the applicant in CA number 410 of 2022, in which these two applications arise out of. Stop. An order was passed in CA number 410 of 2022, which arose out of company petition number 214 of 2012, and by order dated 9/1/2023, the Airports Authority of India was permitted to take all steps and measures for implementing the order dated 3/1/2018. It's all. It was directed that the entire exercise shall be completed within an outer limit of 3 months. Stop. However, CA 245 of 2023 was filed seeking condonation of delay of 93 days in compliance of the order dated 9/1/2023. Stop. Thereafter, CA 251 of 2023 was filed seeking extension of time for compliance of the order dated 9/1/2023, till 30/9/2023. Full stop. Next para. Learned counsel for the applicant submits that acceptable reasons are shown in the affidavit accompanying the application as to the reason why the exercise could not be accomplished within the time frame fixed by this court. Stop. Next para. Learned counsel for the respondent OL submits that having regard to the nature of the exercise that was directed to be undertaken by this court, the official liquidator may not have serious objections to allow the applications, however, it is submitted that directions may be issued to the applicant Airports Authority of India to communicate to the official liquidator every fortnightly the what is that?
Progress.
The progress of the exercise undertaken by the authority in compliance of the directions issued by this court. So, next para. This court is satisfied with the explanation offered in the affidavit accompanying the applications. So, consequently, the time for compliance of the order dated 9/1/2023 passed in CA number 410 of 2022 stands extended till 30th of September 2023. Stop. It is also deducted that the Airports Authority of India shall keep the official liquidator informed of the progress in the exercise undertaken by the authority in compliance of the directions issued by this court, by informing the official liquidator every fortnightly regarding the progress achieved by the authority.
For resolution of the. Your lordship may kindly take 481. For 81 man.
Yes.
When the affairs of the company have been completely wound up, or when the court is of the opinion that the liquidator cannot proceed with the winding up of company for want of funds, assets for which or for any other reason whatsoever, and it is just and reasonable in the circumstances of the case that an order of dissolution of the company should be made, the court shall make an order that the company be dissolved from the date of the order, and the company shall be dissolved accordingly. A copy of the order shall, within 30 days from the date thereof, forwarded to the by the official to the registrar, who shall make
in his books, minutes and dissolution of the company. If the official liquidator makes a default in forwarding a company aforesaid, there shall be financial. Based on this, I have made an application for dissolution of the company. Since I have completed all formalities and nothing more to be done in this company. I have also requested for one small 455. Subject to 455, my lord, your lordship may kindly see 455. Within 2 years, my lord, if anybody is having any difficulty or any other thing, they can make an application for recall of this order. That option is given either to the OL or to the creditors or any other person affected. But I have repeated that section, my lord, in my application itself, my lord, as it is. Page number 9, my lord. 559, my lord, sorry. Where a company has been dissolved, whether in pursuance of this part, section 394 or otherwise, the court may anytime within 559, my lord, sorry. 559. A company has been dissolved, whether in pursuance of this part or section 394. Or otherwise, the court may at any time within 2 years from the date of the dissolution, an application by the liquidator of the company or by any other person who appears to the court or to be interested, make an order upon such terms as the court thinks fit, declaring the dissolution have been void, and thereupon such proceedings may be taken as might have been taken if the company has not been dissolved. This option is given, my lord, by mistake. Something is done, something is kept later. So this provision is made only for that option. Subject to this, my lord, your lordship may kindly order for dissolution. My lord, my application may be kindly. CA 238.
For this purpose, this summons has to be issued.
The
summons has to be issued.
No, no, my lord, the dissolution is between this honorable court and the official liquidator, my lord. Official liquidator says that he has done everything. There is nothing to be done in this case. No assets are there, no liabilities are there, no money is recoverable, no action can be taken. I have, my lord, initially, my lord, winding up order is passed, my lord, it is in between. During winding up order of the dissolution, my lord, I am required to do so many things according to the Companies Act, my lord. I have to sell properties, I have to take action against it. If I complete all these formalities, nothing to be done by me or nothing is done by any other person in this company, my lord, that company gets dissolved.
But no notice is required to be issued?
No.
But then what is this? You have furnished the judge's summons.
Yeah. All right.
You have yourself furnished this judge's summons under section 481.
As one the format is regular. All cases I am required to file this. All cases, whether even for accounts, my lord, I am required to file this. Because the section says like this, so I am required to file this. But this becomes redundant, my lord, as far as now present this thing is concerned. It is a formality that I have to do this. Because my application, my lord, there is no respondents as such. It is a company application where I have reported to this honorable court that I have done what is required to be done completely. If your lordship can have a look at that my application, my lord, my lord, one application, my lord, I may permit you to read, my lord, so that it will be easier for But it is a narration of the facts, my lord. Initially, my lord, it is required to be also to be incorporated in the order of your lordship, my lord, where the entire thing is to be repeated, my lord, as such. The may I read, my lord, para 2 onward. The premier commercial bankers was a firm consisting of 8 partners, so and so, under the.
Where are we reading?
My lord,
Where are we reading?
my lord, my application, my lord, 238. Para 2, man. My lord, para 1 onwards, my lord.
Yes.
The premier commercial bankers was ordered to be wound up by this honorable court by order dated 29/7/83 in company petition so and so. And the official liquidators are attached to this honorable court by virtue of an office becoming a under the provisions of so and so. The premier commercial banks was a firm consisting of 8 partners formed in 29/4/81 under the provisions of the Indian Partnership Act, unregistered companies so and so. The head office of the company was at Rajadinagar, Bangalore, wherein territory of Karnataka. The firm was ordered to be wound up by the petition filed by the few depositors. Copy of the binding of orders kept annexed here. That in consequence of the binding of order, the partners of the company in liquidation as the relevant date were under the statutory obligation to file a statement of affairs with the official liquidator within 21 days from the date of the binding of order under section 454 of the Companies Act, and to hand over all statutory books and records to the official liquidator within a reasonable time. The partners have discharged their statutory obligation by filing a statement of affairs and handed over company's books and records to the official liquidator. The official liquidator has filed a preliminary report on OLR. That by order dated 3/11/98 passed by the 1988 passed by this honorable court in OLR 120 of 88. Official liquidator is permitted to drop the misfeasance proceedings under section 543 of the Companies Act. That only physical assets came to the custody of the official liquidator was some old furniture kept at the branch office, and with the due permission of this honorable court, the official liquidator has realized the sum of rupees 39,590 in the year of 1985 itself. Further, the official liquidator has realized the amount of 3,97,145 towards statutory debts, recovery of debts. That upon filing OLR 67 of 2000 by official liquidator, this honorable court by the order dated 9/11/2000 has permitted the official liquidator to invite claims from the creditors by publishing a claim notice in newspaper. Official liquidator was not able to find any documents confirming the compliance of the said order, either in this office or from the records of the registry. Hence, in order to distribute the available amount to the creditors, the official liquidator has published a claim notice in newspapers in Times of India and with Udayavani on 6/1/23. No claims were received on the notice published. A copy of the order dated 9/11/2000 and copy of the newspaper advertisement are produced. That in order to complete the 40 years old winding up proceedings and for distributing the available amounts to the creditors whose information available, the official liquidator sent individual letters dated 19/5/23 to the petitioning creditors, depositor holders, and the company on the available address. The status of the service of letters is as follows. Returned with postal remarks deceased. Neither acknowledgement cards undelivered received, where website shows that the letter is delivered, but delayed no response from the person. Returned with postal remarks deceased. That since there is no activity as such for the past 4 decades in the liquidation, no litigants by or against the company are pending to the knowledge of the official liquidator. The official liquidator was the view that it is a fit and proper for dissolution, and hence published a common public notice dated 27/5/22 in the following widely circulated newspapers calling for objection, if any, from any person, contributory creditor, workman, government authorities, or any other person interested, or any other person who has reason to be aggrieved by the dissolution of total 17 numbers of companies in liquidation, including premier commercial banks, and send objections, if any, in writing with proper justification to the official liquidator through post or email within 7 days of publication of notice. Name of the newspapers are published. In addition to
this, you have done, which are the requirement of the provisions of the
yes,
law.
The para 9 also, I was filing regularly, half-yearly accounts and also this thing, para 11, para 11. that as could be seen from the previous above section, since the official liquidator cannot proceed with the liquidation for the reasons stated in the above paragraph, the liquidation proceedings of this company in liquidation is pending for the last 40 years, and there is no activity for the past of several years in the liquidation. To the knowledge, this is what is required. To the knowledge of the official liquidator, no further assets are pending for realization. The official liquidator has done all that he can possibly do to wind up the affairs of the company in liquidation, and he has realized the available and known assets as far as he can, and has made efforts to discharge the liabilities towards creditors. As per the available information and records, no cases by or against the company in liquidation are pending, nor there is any inquiry by any public or creditor or public authority, and no objections have been received to the public notice as mentioned in para 8 above. In these circumstances, it may be just and reasonable to dissolve this company under 481, subject to the provision of section 559 of the Companies Act, which is reproduced below.
So this amount will be.
Yeah, Malad, this amount, Malad,
will
available to the credit of the company is 5,96,000, Malad.
Yes.
Para 12, Malad.
Yes.
In view of the circumstances explained in para 6 and 7 above, after paying the expenses like audit fee, income tax, etc., official liquidator may be permitted to transfer the balance amount to the estate and establishment fund account maintained by the official liquidator in Punjab National Bank, Hudson Circle, which will be kept reserved for 2 years for disbursement of any claims, if any, received by the official liquidator. This is under 559. That is all. Malad, prayer portion, Malad, that order that so shall be stand dissolved. Malad, permit the official dissolve from the date of this.
Format?
Yeah, I have given. Malad, stand dissolved from the date of this order. Malad must be there in the order sheet.
Please make the necessary changes in the pencil. Pass it on.
Malad, while making an order, Malad, prayer, Malad, the line is to be added, Malad, it is not there in this Malad. Prayer, Malad, order that premier commercial banker shall stand dissolved so and so as on the date of this order must be there. Right, get dissolved only on the date of this order, order by this honorable court.
Paragraph number 12 ali. Paragraph number 12. Accordingly, Mrs. Premier Commercial Bankers practically in liquidation stands dissolved from the date of this order. Huh? Is that you want that to be
Malad, no. Malad, order must be Malad. The entire thing is to be repeated, Malad, as per the application.
correct? No, you were saying that this one is missing, so that has to be added. What was that?
Malad, as on the date of this order.
That is how.
That is
how it is.
Whatever is there in the previous order, Malad, same thing may be repeated. So,
Same thing. You please make the necessary changes and pass it on.
yes.
Serial number 4. Yes, please.
I'm so sorry, Malad, I was in my legs. And
I
I was under the impression that the seconds take some more time. I'm so sorry, Malad. And Malad, in this matter, I need to get some papers also. I have the papers also, Malad.
Please go through that. We'll have next week.
Please, Malad. Please.
I'll serve one more copy.
It's a matter of seeking extradition and the
Brief,
official liquidator is asking for permission to do the licensing because there is no police involved here. Instead of police, they are asking permission for the OL to make all the communications and license work
Please,
with the MEA.
please,
I don't think. Anyway, you just go through that one
please.
and make your submission.
Under the treaty, my lord, there are two options. One is that judge himself can do the liaising work in terms of doing the affidavit, or an investigating authority can do it. It's the intention of the OL that we do not overburden this court and we take on that responsibility. That is why we have asked for that prayer.
And in this case, there is no question of investigating authorities.
We'll have to see the power of the OL also, whether he gets the same power as the investigation officer or how is it? I just look into it and make my.
All right. Serial number 4 only. At the request of the learned Deputy Solicitor General of India, appearing for the respondent, release this matter on 16th of August.
But may make one request, because till 15th, I may not be able to get it for the reason they not be seeing the Independence Day. So may I request the next week, 23 or
23rd of August.
great. I'm sorry, my lord, I was great.
Appear for the official liquidator.
Yes.
Now, this is the matter that had come up last week.
Hmm.
That small amount of 2 lakhs to be recovered from KSFC for the amounts they owe pari passu.
Yes.
I am not on the small amount or the big amount. The question is not that before initiation of the company liquidation proceedings, KSMC did not exercise the power under section 29, property was sold. Then the company court will not set aside that sale date, not sale made by the KSMC. As against that, the purchaser will not preferred and participant at appeal before the Dissolution court in not in an appeal. It was set aside, sale was restored. As against that, they preferred not appeal to the Supreme Court, civil appeal. That has been dismissed. Now they want to not pay the expenses of incurred by them in the Supreme Court. That's what they are asking. If they are not any amount is spent for preserving my property, they are entitled to recover it. Not for the an order which is confirmed by this honorable court, which has been challenged and it is dismissed. Now they want to pay the advocate's fee, expenses in filing the SLP. No. That's not my objection.
It is an incorrect submission, my lord. What I am seeking to reclaim is the amount that I have spent in advertising to invite claim for the workmen. And how do legal fees kelta illa. And if I may invite your attention to the Supreme Court order itself, everything is decided there. My claim is only this application is made quantifying the claim which Supreme Court had permitted me to incur. If I may invite your attention to the Supreme Court order at annexure E of the application. Page 37. Lordship has it.
Yes.
Please, my lord. This is the Supreme Court order in which the sale was challenged, which the respondent had undertaken during the sale of during the pending of the proceedings.
Yes.
My lord. The law, my lord, as on today, is that if the sale is done prior to the winding up order, this is one of their objections in the written objections. That is why I am addressing it. If the sale is made prior to initiation of proceedings, all of the money can be kept by the secured creditor. If the sale is made after the winding up order, then the statutory charge of workmen under section 529A kicks in. 529A provides for a overriding preferential payment. ಯಾರಿಗೆ ಎಷ್ಟಾದ್ರೂ ಹಣ ಹೋಗ್ಲಿ ಅವ್ರು ತಗೊಂಡಷ್ಟು, even if they are first in the ranking of the creditors to be paid, ಅವರು ಎಷ್ಟು ಪರ್ಸೆಂಟ್ ಹಣ ಅವ್ರಿಗೆ ಇಟ್ಕೊಂಡಿರ್ತಾರೆ, ಸೇಮ್ ಪರ್ಸೆಂಟೇಜ್ has to be given to the OL to distribute to workmen. This is the law manual. This is noted here, and their objection is that sale was completed prior to the winding up order. This is also a conceded position. Now they are inconsistently saying it in objections. If I may invite your attention to page 38. Quote ಮಾಡಿದ್ಮೇಲೆ first parasony. Page 38 ಅಲ್ಲಿ there is a quote, and after that there is one hanging paragraph. The date of winding up and date of sale are both confirmed by Supreme Court. And this is an admitted position by the respondent themselves before Supreme Court. The sale is made in 94, winding up order is made in 93. So clearly no question arises as to sale happening before winding up order or even the initiation of winding
The
up.
winding up order in the company petitions
How this?
filed in 1987-89 was made on 13/8/1993.
Please.
The property taken possession by respondent number 1 was sold to respondent number 2 on 21/2/1994.
Please. This is a admitted position, sir. Amele, the respondent themselves concede this position. If I may invite your attention to further second last paragraph on page number 46. 46 ali Swami, second paragraph, learned senior counsel for respondent. Your lordship has it? Learned senior counsel for respondent number 1, which is the respondent before this honorable court also, fairly concedes that where any verified dues of the workman to be paid, respondent number 1 would be liable for the same to extent of pari passu rights over the proceeds realized from respondent number 2. In fact, even the impugned order has issued a direction in terms of paragraph 4 that sale proceeds are to be distributed in terms of section 529A and 529 of Companies Act. We are thus of the view that rights of the workmen as and when official liquidator verifies the dues are fully protected, as their rights would be pari passu with the rights of respondent number 1, so far as distribution of sale proceeds realized from respondent number 2 are concerned. Thus, in dismissal of appeal is correct, Swami. Our sale na overturn madila, but to the extent that workmen's dues are there, it is a conceded position throughout. And in this case, fortunately for them, no workmen have filed any claims. It is my expense to invite claims which I am asking for recouping. Claims bandidre, in addition to that, nan notice ke ಎಷ್ಟು ಖರ್ಚು ಮಾಡಿದೀನಿ, claim ಕೂಡನು ಕೊಡಬೇಕಾಗಿತ್ತು ಅವರು.
Our letter itself not indicate that 57,883 not towards the advertisement expenses, published notice.
Correct.
And for legal expenses of SLP and OSA cases in 1,27,000.
Yes.
Central government commission and miscellaneous.
Yes. Please give it. Totally.
My lord, in the application, my lord, this is the last pending proceedings in this company for liquidation. As your lordship had dictated the previous order, after allowing this, my lord, an order of dissolution may also be passed. Errad prayer is there. Or that can be deferred for next week also, that prayer. If I may invite your attention. The 2 lakhs bandre, there is nothing further remaining in the company, my lord, so I want to liquidate it.
For that purpose, he will not have any say in that.
Please, my lord.
Order in CA number 79 of 2022. This application is filed by the official liquidator of Messrs. Metallic Soaps and Chemicals, bracketly P, close limited, bracketly in liquidation, close. Taking a direction to the respondent, Karnataka State Financial Corporation, Bangalore, to reimburse a sum of rupees 2,03,540 incurred by the official liquidator, and for a further order to dissolve the company in accordance with section 481 bracket 1 read with section 559 bracket 1 of the Companies Act 1956, read with rule 9 of the Companies bracketly code close rules, 1959. We'll stop next paragraph. An objection is sought to be raised at the hands of the respondent KSFC, stating that the official liquidator is seeking a reimbursement of the said sum as stated in the application, towards the expenses incurred by the official liquidator for pursuing the matter on behalf of the company under liquidation before this court and before the Honorable Supreme Court in the civil appeal number 6079 of 2009. However, learned counsel for the official liquidator has pointed out from the order of the Honorable Supreme Court dated 6th of February 2019 that the reimbursement sought by the petitioner is only towards the expenses incurred by the official liquidator in making paper publication calling for claims, if any, from the workman, as was permitted in law, more particularly section 529 capital A and section 529 of the Companies Act. In this regard, attention of this court is drawn to the last two paragraphs of the order dated 6/2/2019 passed by the Honorable Supreme Court. We stop. It is stated, the Honorable Supreme Court has taken note of the submissions made on behalf of the official liquidator and the senior counsel appearing for the respondent KSFC, who fairly conceded that where any verified dues of the workman are to be paid, the KSFC would be liable for the same to the extent of pari passu rights over the proceeds realized from the sale of the assets of the company under liquidation. Stop. The Honorable Supreme Court took note of the directions given by this court. The paragraph number 4, that the sale proceeds are to be distributed in terms of section 529 capital A and section 529 of the Companies Act. So, following the same, it was directed that the rights of the workman, as and when the official liquidator verifies the same, verifies the dues, are fully protected, as their rights would be pari passu with the rights of the KSFC, so far as the distribution of sale proceeds realized from the sale of the assets of the company in liquidation. So, next para, learned counsel for the official liquidator would further submit that the reimbursement sought here is only regarding the expenses incurred by the official liquidator, and since no claim has come from the side of the workman, nothing is stated about the claim which was permitted to be allowed even by the orders of the Honorable Supreme Court. Next, and regard to the submissions made by the learned counsel for the official liquidator, and on perusal of the orders passed by the Honorable Supreme Court, this court is of the considered opinion that the reimbursement sought by the official liquidator in the application is to be allowed. Next para. Consequently, the application is allowed, and the respondent KSFC is directed to reimburse the amount claimed by the official liquidator. As expeditiously as possible and at any rate within a period of 4 weeks from the date of receipt of a copy of this order. Stop. Next para. Adu idondu beliga idur madvalla dissolution. Adine same.
I'll assist.
Yes.
Take one.
For 2 weeks time, my lord, because my lord, one application was kept pending, my lord, where in the MFA, my lord, where OL is a party. I have requested that my name may be deleted from that OL, MFA. That is no pending in orders. As relieve it is not proper for me to retreat to this. 2 weeks time. By the time, my lord, I have mentioned in that application itself, my lord, but still, my lord, unless that order is there, my lord, it may not be proper for me.
Is this matter after 4 weeks?
My lord, then, my lord, I pray for a week's time, my lord, office application. Legible copies,
a week's time is granted at the request of the learned counsel for the OL for compliance of the office objections raised on CA number 138 of 2023.
Sorry, serial number 10, my lord. On
Illegible
sub-number is there, my lord. Sorry, serial number 9, my lord. Acceptance of affidavit dated so and so, my lord. Filed under rule 300, my lord. Normally, my lord, if there are no accounts, my lord, no transaction, my lord, we are required to file an application under rule 300. Nil accounts are there, my lord. That nil accounts may be accepted by this honorable court, my lord. Accept.
ಮತ್ತೆ ನೀವು ಅವಾಗ ಮಾಡಿ ಸಬ್ಮಿಷನ್ ಯಾವ್ದ್ರಲ್ಲಿ ಮಾಡಿದ್ರಿ?
ಅಲ್ಲ serial number 9 ಅಲ್ಲಿ sub number regarding acceptance of affidavit dated 24/5/23 filed under rule 300 of the company's court rules of the dissolution. Your lordship has adjourned by 4 weeks. This
affidavit dated 24/5/2023
under rule 300 may be accepted by this honorable court as there is no transaction. It is a nil transaction. Your lordship may kindly say rule 300.
ಇದೆಯಾ?
I will correct. Rule 300.
Where the official liquidator has not during the period of account received or paid any sum of money on account of the assets of the company, he shall file an affidavit of no receipts or payments on the date on which he shall have to file his accounts for the period.
That account. I have filed that affidavit, that there are no transactions in the account. That affidavit may be accepted under rule 300, except that nothing is required. But affidavit filed under rule 300 under the company code rules needs to be accepted.
Released after 4 weeks. ಅದಕ್ಕೆ ಮುಂಚೆ the official liquidator has filed an affidavit dated 24/5/2023 under rule 300 of the company's bracket court close rules, 1959. So the affidavit is in compliance of the rule 300. So therefore the affidavit is accepted. Ten ಆಯ್ತಲ್ಲ?
10 1 week.
10 ಆಯ್ತು.
There are two official liquidator reports. One is 16 of 23 and the other one is 17 of 2023. I would have 16 of.
Sixteen and 17.
They're two different properties. 16 pertains to property situated at Pune. 17 pertains to a property situated in Ernakulam. Both these properties were put up for auction multiple times, my lord, since 2017-18. At points in time has failed. Whenever we fix the reserve price as per the valuation report, the market value, then there is a reserve price that is fixed based on the market value. We've received no bidders so far. The valuation report itself has fixed a distress value. This property has been valued by a panel valuer. Now, since we've made multiple attempts in the last 4-5 years and till date we've not gotten a single bidder in 3-4 auction processes, we're seeking permission of this honorable court to fix the reserve price as indicated in the valuation report in terms of the distress sale value. Put it up for auction thereafter. We've also annexed the sale notice, terms and conditions of the sale. I just take your lordship through the report. Lots will have the details of the property at page 2 of the report.
Earlier, this this company was not represented by a learned counsel.
But this is only liquidator report. There are no contesting parties, your lords. By virtue of the provision of the Companies Act, every asset of the company in liquidation is vested with this honorable court. So anything we choose to do in respect of that property, we file a report and seek this court's permission.
Order on OLR 16 of 2023. Yes. A report is filed by the official liquidator, placing the result of the e-auction conducted on 24/1/2023 and seeking permission for re-auction of the property situated at Pune, Maharashtra through Railtel Corporation of India Limited in e-auction mode, considering distress value as reserve price. Next paragraph. Learned counsel for the official liquidator submits that on 2 occasions the e-auction was conducted, the first time on 25/7/2022 and the second time on 24/1/2023.
I may just, the first time it was actually conducted was on 5th September 2018. Then again on 10th May 2019, my lords would find these details at page 2 of the report.
ಹೇಳಮ್ಮ
Was conducted first time on, so. they-
ಇಲ್ಲ ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಟ್ವೈಸ್ ಅಂತ ಬಂತ
They will submit, official liquidator submits it on 2 occasions. The
on 4 occasions.
The e-auction was conducted, first time on 21st,
5/9/2018
and the second time,
ಅಲ್ಲ 5/9/2018 showing the floor price for opening bid price as 27 lakhs. So, second time, auction was conducted on 10/5/2019, showing the floor price as 27 lakhs. So, although one offer was received for 41,30,000, the bidder did not pay the bid amount, and therefore the auction fell through. Stop. Thereafter, on 25/7/2022 and 24/1/2023, auctions were conducted, fixing the floor price at 39,64,000. So, on both the occasions, no bids were received. So, in that view of the matter, it is submitted that the official liquidator may be permitted to fix the reserve price at 29,73,000, which is the distress sale value as opined by
Panel value of it was the valuation report is there.
the panel valuers, approved panel valuers. So, next para. Having regard to the facts and circumstances narrated herein above, this court is satisfied that the e-auctions conducted on 25/7/2022 and 24/1/2023 fell through because the floor price, which was fixed at 39,64,000, seems to be on a higher side, and it did not attract any bidder. Full stop. Next para. Consequently, the application, the report is accepted, and the official liquidator is permitted to conduct fresh e-auction of the office premises. ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ details. By fixing the reserve price at rupees 29,73,000 and the EMD at rupees 3 lakhs. Stop. Next para. The official liquidator. The official liquidator is permitted to publish the sale notice in terms of the draft already furnished
Annexures D1 and D2.
and take out the publication in Times of India, English daily newspaper, Mumbai, Pune and Nasik edition, and in Maharashtra Times, Marathi daily newspaper, Mumbai, Pune and Nasik edition, and to engage the services of Messrs. Railtel Corporation of India to conduct e-auction of the said property of the company in liquidation and to place the result of e-auction before this court. Yes. You have to fix the dates, is it?
No, Manoj, we also have to incur that, we have to be granted permission to incur advertisement expenses and other.
The official liquidator is permitted to incur the necessary expenses for advertisement and other incidental expenditure out of the funds available to the credit of the company in liquidation.
And this may be.
You don't have to fix the dates.
Will be allowed in this.
ಎರಡನೇದ್ರಲ್ಲೂ OLR 17 of 2023 ಅಲ್ಲಿ 3 times ಆಗಿದೆ. 5/9/2018, 10/5/2019 and 4/3/2021. ಆ ಫಿಗರ್ಸ್ ಎಲ್ಲ ಅಲ್ಲಿದೆ, ಅದನ್ನ ನೋಡ್ಕೊಂಡು ನೆಸರಿ ಚೇಂಜಸ್ ಸೇಮ್. Fixing the reserve price at rupees 56,50,000 and EMD of 5,65,000. Newspaper details all ಇದೆ application, page number 5 of the application. Five or six ಎರಡರಲ್ಲಿ ಇದೆ.
This company was in liquidation and subsequently my lord, the liquidation was certified by this one. The company is active now. This is an application filed by the employee, my lord. We filed objection. It's an expired employee.
CA 67 of 22. I appear for the applicant here. Foreign company has filed objections. I have sought for some documents from my client who is now in Tamil Nadu. After he retired, he is aged about 77, 78 years. He sent some papers. I will organize to file a rejoinder. Within 1 week, I file it. We will call after 2 weeks.
Regarding my lord, 67 is concerned.
And there is another application, my lord, CA number 247 of 2023. That application, my lord, identical situation, my lord, other employees, about 106 employees had approached this honorable court. The learned single bench of this honorable court earlier allowed my application, directing that the applicants, the ex-employees of the company, they are entitled for 4% interest from the date of their relieving till the date of payment. That order was taken up in appeal. The division bench of this honorable court has now recently passed an order saying that the applicants are entitled for 4% interest. There is no change in the rate of interest, but from the date of finding of order till the date of payment. Now that is that CA number 247 of 23, that is also respect today, is covered by the judgment of division.
Copy.
But I will serve copy.
Let me give a
Under
copy.
the
my lord.
impression that government is.
247, my lord, he has to give me copy, and also, my lord, the company address is not given, my lord, now the company is active. The nodal office is not represented by the company, my lord, the address also available, let him change the address and give copy, my lord, we file objection. 247 is concerned, my lord. And there is one more CA, my lord, 120, my lord.
For applicant.
That application, my lord, is not maintainable. This honorable court, my lord, in the earlier occasion, the application filed by the same applicant in 413, my lord, allowed this application, and we are adjudicated amount, my lord, therefore 22 lakhs 4,534, my lord. The requirement, my lord, the applicant was required to give an indemnity bond, my lord, regarding the amount. The only contention, my lord, in this application, you don't want to execute the indemnity, because that is, my lord, the order also specifically provide that he is asked to execute the indemnity.
We have this matter next week.
Only on that order.
How can
Already
you-
disclosed, and again, one more
How
application,
can you ask for similar reliefs again and again?
again and again.
It's hit by the principles of res judicata.
This matter.
And more than that, they are only asked, see, even in any type of award or compensation that is to be given, when the matter is pending consideration, and in the meanwhile, there is a direction to release certain amount, it is always to be accompanied by an indemnity bond, because it will be subject to the final outcome of the matter. If you hesitate to give the indemnity bond, then you will not be able to
Kindly see the
have the amount with you.
order, my lord, kindly.
Then,
Senior is engaged in quota number 1. Senior is engaged in quota number 1. We have this matter next week.
Kindly see the order. We are agreed, my lord, to release the amount 22 is adjudicated. Only the given condition also, my lord.
where is that application?
Earlier application, my lord. for-
Allala, the
Now
present
new
application,
120.
120. Objections. Hmm? Correct. Without insisting on the undertaking that the amount payable by the respondent company is not full and final settlement, as the said determination has to be questioned. That is the only prayer.
That's all. And the earlier order, my lord, is clearly mentioned, my lord, in that the undertaking to be given. We will release the amount, my lord, subject to the undertaking.
What is this? Huh?
They are saying that they are not received the money for 15 years. Now they are only trying the matter, my lord. We have no question. The government company, my lord, it was in liberation for almost 15 years.
At the request of learned counsels, Chief Vishwanath or Hegde, appearing for the applicants in CA number 67 of 2022, CA 247 of 2023, and learned counsel Shri B. Ramesh, appearing for the applicant in CA number 120 of 2023, released this matter on 23rd of August.
In Malad, there is permission for sale.
Huh?
Permission to sell the property.
Hmm.
What am I kindly say? But earlier, Malad, last week, Malad was directed to serve a copy on R1 and R2, my lord, your lordship. Well, that services held sufficient. But previous 2-8, my lord, order, my lord, this court has directed notice also to be served on secured creditors who have been arrayed as respondents to application. Accordingly, steps taken by the president, item to confirm submission of the letter court sources accepted. Notice sent to R2 is also served by hand and sufficient health. But I have requested this honorable court to give permission to sell the land. My lord, your lordship may take my CA, my lord, 306, page 6, my lord. Page 6. Para 2, my lord. The company had land and building movable assets, so and so, my lord. Well, so Kudala Gate, Hosur Road, Bangalore, Bomanadi, Nagara Sabha, Bangalore 68.
Yes.
Vacant land measuring 2,400 square feet situated in same place, Mada, Bomanadi, Nagara so. Pursuant to the orders of the binding of possession of the company's assets were taken over by the official liquidator on 2006 and addressed a letter to Canara Bank to furnish the title deeds. As far as the assets of 2A is concerned, the same was sold by Indian Exim Bank under securitization and reconstruction, financial assets and enforcement of securities interest act 2002. That this honorable court by order dated 10/3/2010 passed in CA number 772. Observed that sale made by the secure creditors under Surface Act. Therefore, Act override section 537 of the Companies Act, and therefore sale made in the security creditor is in accordance with law. And there is no need to seek leave of the court for sale of so and so. That 5.1 minute, next para, page 8. That as far as the assets at 2B is concerned, Canara Bank has furnished the title deed to subject to vacant land by so same was brought to the kind notice of this honorable court by way of company application 91/21 by seeking permission for appointment of valuer to value the vacant land. And the same was allowed by an order dated 1/4/2021 by appointing Sri Viraya as final valuator of this honorable court. Valuer has submitted his valuation report in a sealed cover so and so, along with the inventory list and his professional team. The same was opened and it was seen that the market value of the property is in the range of 5,000 to 6,000 per square feet. And the valuer considered the location, land and vicinity of the valuer. Valuer has adopted 5,250 as the market value and estimated the realizable value is 94,50,000 as per the details here and there. He has given the details manner. What is the market rate considered? What is the fair value of the land and also realizable value. Copy of the said order is shown. That valuer so and so has submitted that is for payment of his fees, that para 7 that in order to proceed for sale, the said vacant land in public auction and realize the sale process to settle the claims of the creditors of the company. That as per rule 272 of the company's court rule, every sale shall be held by the official liquidator subject to such terms and conditions as can be approved by the court, and all sales shall be made by public auction by inviting sealed tenders or such manner as the court may direct, and the sale is subject to confirmation by this honorable court. That official liquidator submit that Ministry of Corporate Affairs, Government of India, under whose administrative control the official liquidator functions, has taken policy decision that all the sale may be conducted by e-auction only to bring a uniformity in the working of official liquidator, attached to various honorable high courts and to improve their efficiency, to save cost and time to maintain transparency.
Again by Railtel. Railtel Corporation.
Oh, same thing, Marat. But the recent Marat, it is given Marat. Marat, for that Marat, we are required to pay a charge of rupees 10,000 to them, Marat, in page 11.
All right.
Marat, considering location properties, Marat, official liquidator proposed to publish the sale notice, Marat, in 2 newspapers, Times of India and Vijay Karnataka, Marat. That para 9 Marat. Marat, para 10 Marat, that the respondents are the charge holders of the property and India Exim Bank is having first charge on the property and Canara Bank is having second charge. By letter shown, addressed officially liquidated source of entered assignment deed to L12 Assets Reconstruction Company, for which we have given notice to these two persons. Notice have been served and other notices held to be sufficient by this honorable court. Now 8,90,000 is available to the company. May be permitted to incur all expenditure out of the funds and advertisement charges and incidental expenditure.
No, but if they are holding it as secured assets.
Secured assets, if the secured asset is under Securitization Act, then they can sell the property with an association with the official liquidator. If the security is not under Securitization Act, if it is only a mortgage by section 29 of the KSFC and other Financial Corporation Act, it is only the Companies Act.
But this was done to Canara Bank.
Not a Canara Bank, what happens is Canara Bank also, Canara Bank is only a second charge holder.
Huh?
Para 10, respondents are charge holders of the property and India Exim Bank is having a first charge on the property. Canara Bank is having a second charge. A second charge cannot be equated with it.
All right, even this
No.
India Exim Bank.
Now what will happen is we are only selling the properties and bringing to auction, and whoever is bidding more, the proceedings will be placed before this honorable court for permission to confirm the sale. The sale is confirmed. The other banks also will represent whether the same that rate quoted by them is proper or not. Also is to be considered by this honorable court. If this honorable court comes to the conclusion that the rate quoted by them is proper or above the market rate which the valuer has mentioned here, then this court may not take into so many other considerations, either confirm the same or reject the same.
How are you saying that it doesn't fall under that SURFACE Act?
It is after the sale, but the amount is to be distributed. I have to distribute the amount as per section 529A, 530. I am first charge holder, I have to pay. I have to pay PF first. Later Supreme Court decision, I have to pay PF first prior to all other, including bank first charge.
No, this 2A was given up. The property at 2A was given up on the ground that it is covered by SURFACE under the SURFACE Act.
No, but
you read out just now. In your application, you just out.
Bank has not initiated any action till now, including SURFACE Act. If they have initiated SURFACE Act and taken a then they will sell the property in addition in association with official liquidator. If they have not taken any action under SURFACE Act, there is nothing for them to. They may not prefer to go to SURFACE Act and take action. Otherwise, by this time, in spite of giving notice to them, I have a responsibility to pay to the laborers, or pay PF, in addition to paying to them also. I have to pay to them and pay to the workers also. If they have not taken any action to sell the property, it is bound and duty for me to sell the property as per the provisions of the Companies Act and sell the property, take the proceeds and take permission from this honorable court to pay them 50%, pay to officers, labor 50%. Permission to sell may be given, so that fixing a fair market value as mentioned by the valuer, whatever this page 8, market rate as considered at 5,250, basing on that, I may be permitted to mention as minimum price as 5,250 per square feet. That is the market rate considered by the valuer. Page 8, paragraph 5.2. OL may be permitted to issue a sale notice in this particular newspapers, wherein I have requested for publish the news sale notice in the newspapers, fixing a rate.
Format.
Yeah. I will.
You don't have, is it? You don't have a format.
Alert, right now, alert. Alert, I will furnish the copy.
Only one paragraph says comment. Although notice is served on the respondents, comma, they remain unrepresented. ಒಂದು ಹಾಕೊಂಡು ಮಿಕ್ಕಿದ ಫಾರ್ಮ್ಯಾಟ್ ತರ ಮಾಡಿ. Doing the
Copy.
you will have to give a copy so that I
I
can
will
pass
give
it.
it.
Yes. You have not mentioned the reserve price.
But the prices as per the Malad report, Malad, that page, whatever is the fair market value, Malad,
94 lakhs 50,000.
5,000.
94 lakhs 50,000. It can't be per square feet. Ataralla.
Full,
You will have to see.
the calculate fund.
94 lakhs 50,000. Huh? No, if fair value of the land is shown as 1 crore 26 lakhs. You're not stated what should be the reserve price.
Reserve price andre market value of one is in the range of 5,000 to 6,000 now. Fair market value considered is fair value of the land considered is 1 crore 26 lakhs in page 8, Malad, paragraph 5.2. Page 8.5.
Yes, I've seen.
Fair value of the land is 1 crore.
Correct. What should be the reserve price now?
The same will be the reserve price. ಇದಕ್ಕಿಂತ ಕಮ್ಮಿ ಕೋಟ್ ಮಾಡಬಾರದು ಅನ್ನೋದು
26 lakhs.
ಅಲ್ಲ, ಇವಾಗ ಫೇರ್ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಇದ್ರೆ ಇದಕ್ಕಿಂತ ಕಮ್ಮಿ ಕೋಟ್ ಮಾಡಿದ್ರೆ ನಮ್ಗೆ ಕಮ್ಮಿ ಆಗುತ್ತಂತೆ. ಎನಿಬಡಿ ಹೂ ಇಸ್ ಕೋಟಿಂಗ್ ಮಸ್ಟ್ ಬಿ ಕೋಟ್ ಅಬೌವ್ ದಿಸ್ ಅನ್ನೋದಕ್ಕೋಸ್ಕರ ಅಷ್ಟೇ. ರಿಯಲೈಸಬಲ್ ವ್ಯಾಲ್ಯೂ ಅಂದ್ರೆ ಏನು ಬರದೇ ಹೋದ್ರೆ ಸ್ವಲ್ಪ ಪ್ರಾಬ್ಲಮ್ ಇದ್ರೆ ಅದಕ್ಕೆ ಇವರು ಸ್ವಲ್ಪ ಕಮ್ಮಿ ರೇಟ್.
The application is filed by the official liquidator. Seeking permission to sell the immovable assets of the company in liquidation, in terms of Rule 272 and 273, read with Rule 6 and 9 of the company's (bracket code) close rules, 1959. Full stop. The company in liquidation, namely Messrs. Compudyne, Winfo Systems Limited, was ordered to be wound up on 27/2/2006 in company petition number 175 of 2004, and the official liquidator attached to this court was appointed as liquidator of the company. So, the company had land and buildings and movable assets company had two land and buildings and movable assets, as shown in the application. However, in respect of the assets found at Compudyne House, 7th Milestone, Kudlu Gate, Urve Bhavi Palya, Bengaluru, it is found that respondent number 1 herein, Messrs. India Exim Bank, had sold the property on 10/3/2006, under the SARFAESI Act. Full stop. This court, in company application number 772 of 2006, by order dated 10/3/2010, held that the sale made by Messrs. India Exim Bank is in accordance with law. Stop. The present application is therefore confined to the asset at serial number 2B,
Similarly mentioned, my lord, as vacant land measuring source.
namely vacant land measuring 2,400 square feet, situated at number 56, VP Khata. Adala details alla ide, page number 7 and mark ಮಾಡಿ. Stop. The official liquidator had earlier filed CA number 91 of 2021 seeking permission for appointment of valuer to evaluate the property, and permission was granted by order dated 1/4/2021, appointing the one of the panel valuers to evaluate the property. Full stop. Learned counsel for the OL submits that the panel valuer has opined that the fair value of the land would be rupees 1,26 lakhs. So the realizable value is rupees 94 lakhs 50,000. So ನೀವು ಕೊಟ್ಟರು ಆರ್ಡರ್ ಅಲ್ಲಿ ಎರಡು ಬರ್ತಿದ್ದಾರೆ, ಯಾವ್ದು which one is to be taken as a reserve price?
ಅಲ್ಲ ರಿಸರ್ವ್ ಪ್ರೈಸ್ ಫೇರ್ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ತಗೊಂಡ್ರೆ ಸಾಕು.
ಅಲ್ಲ ನೀವು ಕೊಟ್ಟಿರೋ ಕಾಪಿಯಲ್ಲಿ ಇನ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 3
ಅದ ಹಳೆ ಇದರಲ್ಲಿ ಎರಡು ಕೊಟ್ಟಿದ್ದಾರೆ, ಬಟ್ ಐ ಹ್ಯಾವ್ ಟು ಫಿಕ್ಸ್ ಓನ್ಲಿ ಒನ್ ಮಿನಿಮಮ್ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಫಿಕ್ಸ್ ಮಾಡಬೇಕು. ಕರೆಕ್ಟ್, ಬಟ್ ಅದರಲ್ಲಿ ಎರಡು ಇದೆ.
ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 2 to 5 ಸೇಮ್ ಇರಲಿ. 3 ಅಲ್ಲಿ in view of the valuation report which is submitted, the reserve price shall be rupees 1,26 lakhs and EMD shall be
10%. ಅಲ್ಲ ಇದರಲ್ಲೇ ಇದೆ
10 lakhs 26,000.
10% of that amount.
10 lakhs 26,000.
ಹೌದು.
ಇದೆಲ್ಲ ಸೇಮ್. Yes. Please give a copy of that order.
I will. After the sale is made, oil may be directed to file.
That will not be the content in that order.
Allah, I will, anyhow, I have to file, madam.
Yes.
Please, Lord, I appear for the official liquidator loss. Lord, subserial number 1, Lord, OLR 46 of 23, may kindly for a moment. Lord, the company under liquidation is having two properties. One is situated in Andhra Pradesh and another one is in Gujarat, Lord. And OLR 46 of 23 is potentially Gujarat property, Lord. Not the earlier occasion, Lord, the property was e-auction was conducted by order of this honorable court. Lord, he has not, the successful bidder has not come forward. Therefore, we made another prayer to appoint the fresh valuer, Lord. The earlier occasion, Lord, the property was valued in 2018. Therefore, in view of the appreciation, Lord, we have sought for the prayer to revaluation. Lord, we made a request to the OL attached to the Honorable High Court of Gujarat, Lord, to submit the valuation estimation. Lord. It will be taken up next week. Lord. We will furnish that copy.
My lord, in
paper publication, that anybody is there in the government. Again, we have given our affidavits and also proper necessary documents, but we are not given any communication, we are not invited as a party, and that's the reason I have filed an application to recover the dues of the employees provident company. I am maybe alone, and I may be committed to consider my dues which I have given along with the documents.
as per the required format annexation and also everything, they can consider and pay the amount to reduce the official liquidator, realizes the amount.
ಯಾವ್ದು ನಿಮ್ದು?
14,
ಹಾ?
14, serial number 14.
Not in C.
ನಿಮ್ದು ಅಪ್ಲಿಕೇಶನ್ ಯಾವ್ದು?
Some application, application.
52 of 2022.
Copy is not served in the.
Last time I said that.
I'll trace out and make the some file, my lord, I will file the objection.
ಇಲ್ಲಾಂದ್ರೆ ಬನ್ನಿ ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡಿ. Please give copy.
I'll give one more.
My lord, I appear for the respondent in OLR 327, serial number 3. I filed a memo for retirement, my lord. Serial number
Here are
3.
serial number 14.
14 ali, sub-serial number 3, OLR 327 of 11.
ಹಾ.
For permission antide. That matter, my lord, I filed my memo for retirement on 21st April. I have also produced the postal details showing delivery of my letter. My lords, we have not been able to be in touch with them. They have not given us any instructions in the matter, my lords. My memo for retirement may be accepted.
I don't accept retirement memos like that.
My
Unless.
lords, a notice may be issued to the party directly, my lords.
No,
because
we are not. Why should the court issue court notice? It is between you and your party.
My lords,
Why
they're
should court
not,
is-
they're not,
Why should court issue court notice?
my lords, they're not responding to us, my lords. We have no instructions from them whatsoever.
We will adjourn the matter and we will indicate the next date of hearing. You will have to communicate to the party that this is the next date of hearing. And if you don't come and appear and make alternative arrangements, we will seek retirement from the
We've
matter.
done that, my lords.
And
We have
that
written a letter
communication
also. my
along
lords.
with acknowledgement has to be furnished.
We'll
before the
furnish
court.
the acknowledgement cards, my lords. We also have the acknowledgement cards. We've issued the letter as well, my lords. May
Indicating
kindly
the
see
next
my
date of
memo.
hearing.
We will file the
Please do
memo today itself, my lords.
You are
with
not
the
going to issue
acknowledgement
court
cards.
Yes.
But
We will
OLR
find them.
46, a week time may be accommodated, lord. 46 of 23, my lord. Yes, we have requested the OL attached to the.
Learned counsel. For the applicant in CA number 52 of 2022. Has served a copy
Please,
of the IA on the learned counsel for the official liquidator.
please, 2 weeks time. may be accommodated.
Learned counsel for the official liquidator seeks for 2 weeks accommodation on the ground that the official liquidator has written to the official liquidator at Gujarat,
Please,
attached to the High Court of Gujarat, seeking a valuation report
Please.
regarding.
My lord, this is my submission is pertains to the OLR 60 to 46 of 20.
ಹೌದು.
Please,
ಅದನ್ನೇ.
in this matter, I am seeking for a week accommodation.
Correct, sir. But you made a submission that you have requested for that matter.
Sorry.
ಏನಂದ್ರೆ? Hmm?
They have provided in the secondary. What is the free driver? What is your work? And then you have to complete. You have to get the detail.
Correct,
That will be right.
correct. But the valuation report is yet to be received. So. As far. Learned counsel. Appearing in OLR 327 of 2011 for the respondent. You are appearing for whom?
Yes, my lords, respondent, my lords.
For the respondent submits.
My lord, this OLR is in between the honorable court and the official liquidator.
I don't know where she is saying respondent.
For the
Which
commercial,
respondent?
for the commissioner of commercial taxes, my lords.
But there is no such respondent in that OLR.
But my lord, that OLR 327 of 14 that we will not trust now.
You are not proceed.
Because that OLR 34 has to be considered, Lord. In consideration of that, Lord, that has to be infectious, become infectious. Lord.
ಅದು ತೆಗ್ದಾಕ್ಬಿಡಿ. learned counsel for the official liquidator submits that OLR 327 of 2011 is not pressed and the same may be disposed of. Stop. The submission of the learned counsel for the official liquidator is placed on record and OLR 327 of 2011 stands dismissed as not pressed.
It has withdrawn
Dismissed as
or
withdrawn.
infectious or become infectious.
So your problem is solved.
Yes, my lord.
Release this matter
Lord,
on 23rd of August.
Lord, OLR 34 of 23 may kindly be taken up for a movement, my lord.
Hmm.
My lord, this is pertains to the property situated at Andhra Pradesh, my lord. Lord, there is an, Lord, the writ petition is pending consideration before the High Court of Telangana, my lord. Lord, we have to engage an advocate because the advocate engaged in the Telangana from the official liquidator at Bangalore, Lord. He has given a no objection, Lord, because he has not conducted. The employees are suffering almost over 300. Therefore, we have requested to appoint one of the MN Kumar Lord to appoint to conduct the case, the writ petition, which is pending before the Telangana High Court. Lord. That may be considered, Lord. Because the employees are suffering for the past 12 years. Lord. There is no response by the advocate who is conducting in the case. Lord.
ಮುಂಚೆ order on OLR 34 of 2023. When the counsel for the official liquidator submits that the learned counsel appearing for the official liquidator before the High Court of Telangana in petition number 7403 of 2012 has given a no objection certificate and has requested the official liquidator to engage the services of any other learned counsel on the panel.
In prayer,
Comma, the official liquidator is seeking permission of this court to engage Sri MN Kumar, central government senior standing counsel to appear on behalf of the official liquidator in the above said writ petition. Full stop. Next paragraph. Permission is granted. Full stop. The official liquidator is permitted to engage Sri MN Kumar, learned central government senior standing counsel to appear and represent the official liquidator attached to this court in writ petition number 7403 of 2012. Yes. Release this matter on 23rd of August.
Much okay. OLR may be disposed of.
OLR is accordingly disposed of.
Yes.
OLR 71 of 2023. It is quite similar to the orders your lordship passed in till number 11, my lords. This is also for sale of assets, the land, building, plant, machinery, some equal trees. I just point out relevant My lords would have page number 3.
The previous e-auctions.
Please, my lords, this identical reliefs are being claimed in respect of different properties.
When were they brought for auction? Earlier?
Earlier, my lords, this is the first time we are putting it up for auction.
First time.
This is first. And this is at the current valuation price.
Yes.
This is the very first attempt.
Then you please make the necessary corrections in that format and pass it on.
Please, my lords, I'll do that. I will give the details of the assets that we seek to move along with the reserve price and
Yes.
the details of the paper public.
Yes. So OLR 71 of 2023 is disposed of. Yes. Sixteen.
I appear for the official liquidated.
Manoj, I appear for the respondent. They sought for an initial deposit of 1 lakh rupees from the creditor who had initiated the liquidation process. Manoj, 1 week's time may be given. I'll either file objections to this IA for reduction of cost, or I'll agree to it subject to my client's instructions. I didn't do the client. This was shared with us about 4-5 days ago.
No, the order was passed on 28th of July 2015, my lord. The amount has to be deposited within 30 days, my lord.
Please,
1 lakh rupees initial deposit.
Manoj, in fact, we had ourselves approached the liquidator, the office of the honorable liquidator, once the order had been passed, indicating to them that they should let us know what the cost should be. The matter has been pending for 3 years, my lord. We have done our bit of compliance. I only request 4 days time, my lord. It may be on Monday. I take instructions from my client. If my client is agreeable, or I'll file for minor reduction, my lord.
Notice was required to be published. Please,
It has been published.
it has been published.
It's been published. We published it. We served ROC.
The acknowledgement has to be served.
I filed it. I served it as well.
For taking the paper publication, not there, that has to be reported before the ROC, not, and in turn, the acknowledgement has to be produced before the official liquidator. That has to be.
I don't, there's an order of this honorable court recording that compliance. There's an order of this honorable court recording that compliance is.
When is that? That order itself was passed on 16th of June 2022. After that, the matter had come up last week. That's all. No other orders here.
Last week, I was not even served with this application when I applied.
Right, madam. But you said there is already an order noticing compliance.
The taking of paper publication as well.
There is no such order here.
The order dated 4/1/2023. Council appearing for the petition.
4/1.
January. Then 8/2. The report filed by petitioner that is in compliance.
In which one, madam? I don't find anything here. Huh?
copy in the company petition file, my lord.
No. There is no such order here.
17.
Are you?
Lordship, I am for the petitioner.
You are not appearing in serial number 16,
I am for the serial number
17. This is serial number 16.
Because they are not communicated with the, we communicate the petitioner.
Huh?
They are not.
Non-filing of acknowledgement for having served copy of CA number 115 of 2023. On the other side, who has filed that CA? 115.
Not 115 we have filed, not for direction to deposit
You have
the.
not served a copy on the other side.
Received or not?
You have received it. Learned counsel for the respondent submits that he has received copy of CA number 115 of 2023. Next. Non-filing of copy of paper publication.
That my lordship, 2 weeks time may be granted, my lordship, because we are unable to contact the petitioner, respondent here.
Why
There is a direction. There is a direction for amount of deposit of 1 lakh rupees per liquid.
No. This is regarding non-filing of copy of paper publication. Why have you not furnished copy of the paper publication?
Can be granted.
Huh?
2 weeks time may be granted.
That order was passed in June 2022, isn't it?
Within 14 days, they have to take out the paper publication under rule 113.
My lordship. A number,
Next para regarding the paper publication. It should have been taken out by the respondent in terms of the order of winding up passed by the court.
Petitioner has to be taken out of the paper.
Huh?
Petitioner has to be taken out of the paper publication.
Passed on 16th of June 2022. The learned counsel for the respondent for the petitioner who had filed the company petition seeks for a short accommodation to place the copy of the newspaper carrying the paper publication. Stop. Release this matter on 16th of August.
2 weeks time may be granted, because we are unable to communicate the petitioner. Unable to communicate the respondent hearing.
What are the consequences if they have not carried out the paper publication?
That order has to be recalled consequent upon that. Winding up order has to be recalled.
Take necessary application.
May I submit, Millard? They have petitioner for winding up of that company, Millard. Petitioner has to do the exercise by publishing the newspaper in 14 days, Millard.
Yes.
At the same time, this honorable court directly petitioner to deposit initial expenses with the official liquidator also supposed to deposit, Millard. Since the order is not disclosed any directions for initial deposit, Millard, that's why we have filed application for seeking directions, Millard. At the same time, the petitioner failed to produce the proof of publication, Millard. If both they failed, Millard, this honorable court having power to recall that petition, Millard. Now the company will survive out of the liquidation.
Okay, you take this order and you will not, you do not know what are the consequences if a paper publication is not taken out. Huh?
The lordships kindly. Lords,
Have you taken out the paper publication?
lords, at an earlier juncture we had taken, now we have not taken, because there was an interim and a long delay in the matter being listed.
No, there is no question of taking paper publication again and again. You are required to take out paper publication in accordance with law.
Taken out once.
Why have you not furnished a copy then?
But sir, originally, when the liquidation itself was ordered, that time we have taken out paper publication.
So that was done on 16th of June 2022.
Much earlier than that, I've taken out on paper publication.
We are not concerned with that one, sir.
After that, we have not taken.
Then what the consequence then? The entire exercise is a failure.
I'll file an application, my lords, for
For what?
extension.
No. The law requires within 14 days you have to do it.
From the date of order.
Anyway, we will have it next week. You get a clarification. If you have taken out paper publication, you file it, or you file an application seeking extension upfront. I do not know whether that can be allowed. We will consider it.
Please. My sincere apologies.
Proposal for the petitioner respondent seeks short accommodation to place the copy of the paper bearing the paper publication released to released this matter on 16th.
16th of August. Yes.
In the meantime, let them deposit the initial amount of fees as per the order.
Allah, if there is a failure, then the entire thing will go out of the use.
Lord, your lordship has observed that to production of publication. That's why I made a submission.
Correct. If they have furnish a copy of the paper publication, the next steps will follow.
Company has to be.
Yeah, otherwise the order itself will become null and void now. We'll have to recall that order. Yes.
Appear for the official liquidator. It's also similar to the earlier. 16.
16.
17. We have filed it, in fact, the order is 8-2.
You have taken out paper publication.
Paper publication, I will-
In this one, it has been noticed, is it?
Finding of order and response.
No. Compliance of that requirement has been noticed here in this matter.
On the order. 8th of February 2020. If that's the order, January. And my lords, I've filed.
Undertakes to file certified copy of the winding up order of the company in liquidation in the office of the ROC within 1 week. Undertaking recorded. But what about the paper public non-filing of acknowledgement for having served copy? Oh, it's only that much.
Paper publication finding of order was done, my lords, memos on record.
That is not the objection here.
The application is for payment of initial deposit, my lords, of 1 lakh rupees. It may be given time until next week. Inform my client. If my agreeable, my lords, then he will come and agree. If there is some difficulty.
At the request of learned counsel for the respondent, release this matter on 16th of August. No, only Wednesday.
My lord, I appear for the petitioner in serial number 19.
Yes. Yes. 18.
Apologies, my
Serial
lord.
number 18.
Apologies, my lord.
Number 18.
The petitioner was required to furnish the correct address and take steps for service of notice on the respondent. Stop. Finally, 2 weeks' time is granted to do the needful. Stop. Release this matter on 23rd of August. Will stop. If the correct address is not furnished and steps are not taken for service of notice on the respondent, the company petition will be dismissed. Huh? ಒಂದು ವರ್ಷದ ಮೇಲಾಗಿದೆಯಲ್ಲಮ್ಮ.
Lord, I appear for the petitioner in 19.
Yeah. No, it is only for the valuation report of the registrar.
Yes, Your Lordship.
Huh?
It's been 2 years since we filed the affidavit with our schedule of assets.
ಹಿಂಗಾಗ್ಬಿಟ್ರೆ ಭಾರಿ ಕಷ್ಟ.
The affidavit has been served on them on 2 occasions, Your Lordship. We filed a memo with the acknowledgement of service.
ಅಲ್ಲ ನಿಮ್ಮಲ್ಲಿ ಅದೇನು ಇನ್ಫಾರ್ಮೇಶನ್ ಇಲ್ವಾ ಅಲ್ಲಿ? See, I will read out this order for your benefit. 14/7/2022. This matter has been disposed of long ago. However, the valuation report of government advocate has not been filed, resulting in the decree not being drawn up and stamp duty not being collected for and on behalf of the state, resulting in serious loss to the exchequer. Learned government advocate is directed to file necessary valuation report within 4 weeks from today. If the valuation report is not filed by the government advocate, the affidavit and valuation filed by the petitioner would require to be accepted. More than 1 year now. We'll accept the and I think we'll have to also order necessary action against the concerned, because if there is failure on the part of the registrar to give the valuation report and it's causing a loss to the state exchequer, then action has to be taken. We are not going to leave it like this. Barkali. On 14/7/2022, the following order was passed. Extract monthly. In spite of such observation and directions being made by this court, till date, the valuation report has not been submitted. Full stop. However, at the request of the learned AGA, release this matter on 23rd of August 2023. Full stop. If valuation report is not submitted by the next date of hearing, serious consequences will follow regarding the concerned officials. Yes. Matter is called out. There is no representation for either of the parties. So, it is noticeable that by order dated 29/3/2023, this court had directed the petitioner to take out fresh advertisement regarding winding up of the respondent company, within a period of 2 weeks. So, thereafter, the matter was adjourned by 4 weeks on 28/6/2023. So, office has reported non-compliance of the orders passed by this court on 29/3/2023. Full stop. Next para. Release this matter on 23rd of August 2023. Full stop. If there is no representation for the petitioner and if there is no compliance of the orders passed by this court on 29/3/2023, the company petition will have to be dismissed.
Fifty-one, my lord, I pray for 2 weeks time, my lord. I have to get copies of that evidence, my lord. I could not get copies.
Article number 21, at the request of the learned counsel for the official liquidator, release this matter on
2 weeks, my lord. I have applied for copies, my lord.
23rd of August. Yes. Number 3, correct.
Number 3. Number 1, not a record here for the petitioner.
Yeah.
But this is a petition filed under Section 9 of the Arbitration Act, seeking interim relief, my lord, an international commercial arbitration, because my lord, 2 of the respondents are based outside India in Mauritius. My lord, this is one petition which is part of a series of other petitions. There are 3 other petitions, my lord, which are listed before your lordships on the 23rd next week, my lord. So, my lords, please permit me to produce, my lord, the orders in those matters. Permit me to make my submission. The lordships have granted an interim order in those petitions. The facts are entirely the same. We petitioners, my lord, are employees. Based on the profit to be earned by the respondents, my lord, we were entitled to a certain share. That business, my lord, is a fund. They are now liquidating all of their assets, and we are entitled to be paid. So the limited relief was, my lord, that without securing us, they should not pay anybody else. We have no difficulty, my lord, if they make payment to any others. But it is only, my lord, that the amounts due to us may be disclosed and secured. That's the relief sought, my lord, in IA number 1, along with this.
No, office objections are regarding.
There are 2 objections are there, my lord.
Yeah.
One is, my lord, the office directed me to produce the original of the agreement containing the arbitration clause.
Yes.
It is only a letter, my lord, where they say that I have some entitlement. It is countersigned. In a proceeding under Section 9, my lord, there may be no requirement to produce the original, unlike, my lord, under Section 8 or 11 of the Act. Formally, my lord, under the statute, while in Section 8 it is specifically mentioned, in 9 it is not required as per the statute, my lord. That is my submission as regards that. The other objection, my lord, was that in the prayers, the annexure and the date should be mentioned. That is mentioned, my lord, prayer A, that is clear. Lords, may please see at page number 39.
For the petitioner.
For petition.
Regarding office objections, that the original agreement dated 2/11/2017 and original letter dated 27/5/2019 are not produced by the petitioner, learned counsel submits that as required under section 11 of the Arbitration and Conciliation Act, where the original agreement is required to be produced, there is no such requirement in a case arising out of section 9 of the Act. So, any of you have that originals with you?
I will collect it from the client.
Nevertheless, it is submitted that the originals will be submitted after securing the same from the petitioner who is residing at Singapore.
I'll seek instructions of that.
In the meanwhile, it is submitted that under similar circumstances, this court has already granted relief to such petitioners in APIM 6 of 2023 and 6 to 9 of 2023, and therefore the learned counsel prays for similar interim orders. Full stop. Next para. Issue emergent notice to the respondents. Returnable by Sixth Raja idea, 6th of September.
May I make a request, my lord? In the other connected petitions, the first respondent who is contesting is represented by counsel.
No, that's all right, but we'll have to give that time as mandated.
Yes.
For issuance of notice.
Yes, please.
We will permit you to serve a copy on the learned counsel. That is a different matter.
Yes.
6th तारीख September Rajana. On 13th of September, the petitioner is also permitted to serve a copy of the petition along with annexures on learned counsel for
R1.
respondent number 1, who is said to have entered appearance in APIM 7 to 9 of 2023.
6 to 9.
Huh?
6 to 9.
6 to 9. All right. Next para. In terms of the interim orders passed in APIM 6 to 9 of 2023, the respondents are hereby restrained from making any payment of carried interest.
Either date of the document. Very annexed C, other than annexed C and D, either very annexed C.
Yes. Matters called out. There is no representation for the petitioner. The office has put up a note that there is no compliance of the directions issued by this court on 25/7/2023. Regarding deposit of rupees 3 lakhs, it was required to be made by the petitioner with the third respondent bank. So, consequently, the petitioner is not entitled for continuation of the interim relief. So, next para. Reads this matter on 22nd of August. If there is no representation for the petitioner on the next date of hearing, the writ petition will be dismissed.
I appear for the petitioner, my lord. My lord, what has happened is, my lord, the petitioner number 3 is died on 5th, my lord, 5th of this. Therefore, I seek 2 weeks time, my lord, for further payment. Petitioner number 3 was the paying the loan, my lord. The guarantor. He took loan in the name of his wife, my lord.
So there is no complaints.
No, my lord.
No complaint. You will dismiss the writ petition. Purple.
Petitioner must be applied, my lord, on 5th, my lord.
So there are 3 petitioners here.
Petitioner number is wife, my lord.
Houdre, you know what is the consequence? Yen madodu, what can we do?
2 weeks further.
No. Not possible. There is non-compliance of the directions issued by this court on 25/7/2023. Since the petitioner has not deposited, the petitioners have not deposited 30% of rupees 8,60,868, as was directed in the order dated 25/7/2023. Full stop. Consequently, the interim relief that was granted in favor of the petitioners cannot be continued. Full stop.
There was settlement talk was going on.
Yes. We'll continue at 2:30.
What up, sir?
Second list is, huh?
List number 1 matters ಏನಾಗಿದೆ sir?
ಅರ್ಜುನ್ ಆಯ್ತು ನಮ್ಮೆಲ್ಲ ಆರ್ಡರ್ ರಿಪೋರ್ಟ್ ಫೈಲ್ ಮಾಡಕ್ಕೆ ಇದೆ, ಫೈಲ್ ದಿ ರಿಪೋರ್ಟ್.
Serial list 1 ಅಲ್ಲಿ serial number 70 ಏನಾಯ್ತು sir?
ಅದೇ ಮೇಡಮ್, ಟು ಆಡಿಟರ್ ಟು ಫೈಲ್ ದ ರಿಪೋರ್ಟ್ ವಿತಿನ್ 4 weeks.
ಸರಿ, thank you sir.
ಯಾವ್ದು ಮಾಡ್ತಿದ್ದಾರೆ ಅಂತ ಗೊತ್ತಾಗಲ್ಲ. ಅದೇ ದೊಡ್ಡ ಪ್ರಾಬ್ಲಮ್. ಡಿಸ್ಪೋಸಲ್ ಎಲ್ಲೋ ಕಾಲ ಆಗಿದೆ. ಏನಾದ್ರು ಎಫ್ಐಆರ್ ಸಾಕಂತ ಯಾರು ಗೊತ್ತಾಗ್ತದೆ ಯಾರು ಬಿಡಿ ಅವ್ರ ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ. ಅವ್ರು ಹೇಳ್ಬಿಟ್ಟಿದ್ರೆ ಈ ತರ ತೋರಿಸಿ ಅಂತ. ಈಗ ಗೊತ್ತಿದ್ದ ಏನ್ ಮಾಡೋದು ಈಗ ರಾಶಿ ಈಗ ಏನೋ ಡಿಸ್ಪೋಸ್ ಆಯ್ತು ಅಂತ ಇಟ್ಕೊಳ್ಳಿ. ಯಾರಿಗೆ ಅಂತ ಈಗ ರಾಶಿ ಇದೆ ಏನು ಒಂದು ಗೊತ್ತಾಗಲ್ಲ. ಇನ್ನೊಂದು ಇಷ್ಟು ದುಡ್ಡಿದೆ ಅಲ್ಲೊಂದು ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಪ್ಲಿಕೆಂಟ್ CA ಹೌದು ಅಪ್ಲಿಕೆಂಟ್ ಆಯ್ತು. ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು ಬರ್ತಾರೆ?
ರೆಸ್ಪಾಂಡೆಂಟ್ ಆಗಿದ್ದಾರಲ್ಲ CA ಅಪ್ಲಿಕೇಶನ್ ಈಗ ಒಂದು ಅಪ್ಲಿಕೇಶನ್
ಅವರೆಲ್ಲ ಅಪ್ಲಿಕೆಂಟ್ ಗೆ ಅಡ್ವರ್ಟೈಸ್ ಆಯ್ತು. ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು? ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಲ್ಲ COP ರೆಸ್ಪಾಂಡೆಂಟ್ ಅವರು petition ಅಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇವರು ಪಿಟಿಷನ್ ಅವರು ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್. ಈಗ CA ಅಲ್ಲೆಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡವರು ತೋರಿಸ್ತಾ ಬರ್ತಾರ ಅವರು ಅಪ್ಲಿಕೆಂಟ್ ಇನ್ ಸೋ ಅಂಡ್ ಸೋ ಅಪ್ಲಿಕೆಂಟ್ ಇನ್ ಸೋ ಅಂಡ್ ಸೋ ಅಂತ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು? ಯಾರೋ ನಿಂತ್ಕೊಂಡಿರ್ತಾರೆ ಯಾರಿಗೆ ಯಾರು ಅಂತ ನಮ್ಗೆ ತೋರಿಸಲ್ಲ. ಇಲ್ಲ ಅದೇ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಾ ಇರೋದು. ಇದಾಯ್ತು. ಸೀರಿಯಲ್ ನಂಬರ್ 5 ಬಂದಿದೆ. ಈಗ 136/23 ಡಿಸ್ಪೋಸ್ ಆಯ್ತು. ಯಾರಿಗೆ? ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರಿಗೆ? ಯಾರ ಅಪ್ಲಿಕೆಂಟ್ ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್? ನಾನ್ ಬರ್ಕೊಳ್ತೀನಿ ಹೇಳಿ. ಯಾರಿಗೆ? ಅಪಲೆಂಟ್ ಅಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್. ಅದನ್ನೇ ಹೇಳ್ತಾರೆ ಈ ತರ ಬರೀತಾರೆ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ. ನಾನು ಎಷ್ಟು ತಲೆ ಕೆಡಿಸ್ಕೊಂಡು ಎಷ್ಟು ಇದು ಮಾಡಿದ್ದೀನಿ ಮೂರು ಸರಿ ತೆಗೆದು ನೋಡಿ ಕೈಯಿಂದ ತೆಗೆದು ನೋಡಿ ಎಲ್ಲ ಮಾಡಿ ಇವೆಲ್ಲ ಹಂಗೆ CO.CA ಯಾವ್ದು ಮೇನ್ ಇರುತ್ತೋ ಅದಕ್ಕೆ ಹಾಕಿರ್ತಾರೆ ಫೈಲ್ ತೆಗೆದು ನೋಡಿ ಫೈಲ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ಇವರು ಅವ್ರಲ್ಲ ಯಾರೋ ಹಾಕಿ ರಾಘವೇಂದ್ರ ಬಸವರಾಜ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದವರು ಅವರು ಅಲ್ಲಿ ಏನ್ ಹಾಕಿದ್ದಾರೆ ಏನು ಹಾಕಿದ್ದಾರೆ ಅಫಿಷಿಯಲ್ ಅವ್ರಿಗೆ ಎರಡು ಬರೀ ಇದೇ ಗೋಡೆ ಏನೋ ಇದು ಗೊತ್ತಾಗ್ತದೆ ಇನ್ಯಾವ ಆಗ್ತದೆ ಏನೋ ಡಿಸ್ಪೋಸ್ ಆದ್ರೆ ಏನ್ ಬರೆಯೋದು ಅಂತ ನೋಡ್ತಾ ಇದ್ದೀನಿ ನಾನು ಗೊತ್ತಿಲ್ಲ ಚೇರ್ ನೆನಪಾಗಿ ಅರವಿಂದ ತಗೊಂಡೇ ಇತ್ತು ಯಾರಿಗೆ ಕನೆಕ್ಟೆಡ್ ಬೇರೆ ಒಂದು ಬೋರ್ಡ್ ಕನೆಕ್ಟೆಡ್ finally ಡೇಟ್ ಆಯ್ತಾ ಯಾವಾಗ ಓಕೆ 23rd ಅಲ್ಲ ಥ್ಯಾಂಕ್ ಯು ಸರ್ ಕೆಲಸ ಮಾಡ್ತಾರೆ ಅದು ಎಲ್ಲ ಹೇಳಿದ್ರೆ ಅವ್ರು ಬಂದು ನೋಡಿ Friday ಅಲ್ಲ. ಯಾವ್ದೋ ಒಂದು ಪಾಠ ಬಂದಂಗೆ ಅನಿಸ್ತಾ ಇದೆ. ರಜೆ ಹಾಕೊಂಡು ರಜೆ ಕೊಟ್ಟರೆ ಬರಕ್ಕಾಗಲ್ಲ ಎಲ್ಲ ಊರಿಗೆಲ್ಲ ಹೋಗ್ತೀನಿ ಅದೆಲ್ಲ ಯಾವಾಗ ಮಾಡಿ ಹೇಳ್ತಾರೆ ನಮ್ಗಲ್ಲ ಇಲ್ಲ ನಮ್ಗಿದೆ ವರ್ಕಿಂಗ್ ಇದೆ ಯಾಕೆ
ಅದೊಂಥರ ಚೆನ್ನಾಗಿ ಬರುತ್ತೆ. ಅಲ್ಲಿಗೆ
ಎಲ್ಲ ಮಾಡ್ಬಿಟ್ಟು ಕಳಿಸ್ಬಿಟ್ಟಿದ್ದೀವಿ Saturday working days are sitting days in the working days are sitting days. Sitting days are working days are office working days are sitting days. ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಏನಿಲ್ಲ ಇರಿಟೇಷನ್ ಕೂಡ ಪ್ರಾಬ್ಲಮ್ ಅಂದ್ರೆ ಎಲ್ಲ 2 ಗಂಟೆಗೆ ಆಗುತ್ತೆ ನೀವು ಅವಾಗ ಇಲ್ಲಿ ನಮ್ಮ ಬ್ಯಾಂಕ್ ಇಲ್ಲ ಎಲ್ಲಿ ತುಂಬಿಕೊಂಡ್ರೆ ಡಿಸೈಡ್ ಆಯ್ತಾ ಯಾವೆಲ್ಲ ರೇಟ್ಗಳು ಕರೆಂಟ್ ಸಂಬಂಧ ತೋರಿಸಿದೀವಿ ನಾವು ಮೇಬಿ ಅಂತಾನೆ ಹೇಳ್ತಾರೆ ಇರಲೇಬೇಕು ಅನ್ನೋದೇನಿಲ್ಲ ಮೇಬಿ ಅವರನ್ನೇ ತೋರಿಸಿ ಎಲ್ಲ ಮಾಡಿ ಇದು ಮಾಡಿ ಎಲ್ಲ ನಾವು ತೋರಿಸದೆ ಅವಾಯ್ಡ್ ಮಾಡಿ ದೀಪಾವಳಿ ಅದು ಇದು ತಗೊಳ್ಳೋದಕ್ಕೋಸ್ಕರ ಏನು ಕೊಡ್ಬೇಕು ಸ್ಪಾರ್ಟ್ಸ್ನ ಸೇರಿ ಎಲ್ಲ ಸಪರೇಟ್ ಕೊಡ್ಬೇಕು ಒಂದು ಟೈಮ್ ಇರುತ್ತೆ ಇದೆಲ್ಲ ಯಾರೋ ಏನೋ ಮಾಡ್ತಾರೆ
Court officer? Court officer? Court officer? Court officer?
ಹೌದು ಅವ್ರನ್ನ ಎತ್ಕೊಂಡು ಇದ್ರಲ್ಲಿ ಎತ್ಕೊಂಡು ನಮ್ಮ ಚೇಂಬರ್ ಕೊಡೋಲ್ಲ ನೀವು ಕೊಡ್ತಿದ್ರು ಅಂತ ಅದಕ್ಕೆ 3 ಹುಡುಗಿ ಏನೋ ಒಂದು ಕೊಡ್ತಾರಂತಲ್ಲ ಕಾಣಿಸ್ಕೊಂಡು ಇಲ್ಲ ಇಲ್ಲ ನಮ್ಗೆ ಬರ್ತಾ ಇದ್ದ
Court officer? Court officer?
Number 1.